All right. I see everybody is starting to join us. Wow, we've got a great response already. Good afternoon, everybody, and happy Thursday. We are excited to have you with us today. Boy, you are in for a treat because we have Tom Vesper back with us, incredible trial lawyer out of New Jersey, and we've got Todd Romano coming back with us, an incredible trial lawyer out of West Palm Beach in Florida. And you guys are in for a treat. These slides, I'll make sure you get a copy of it after the webinar ends, as well as a copy of all of our speakers, contact information, including all of our amazing partners that you're going to meet over at HMR, On Point Legal Nurse Consulting, Strategic Relationships, and Fox AE. These are four incredible companies that we work with on a day-to-day basis, and they do some incredible work. So I can't wait for you to learn about what they do, unless you know them already, which is great. Let's go ahead and get started. And I'm going to go ahead and introduce just briefly Todd Romano. If you've not had a chance to meet him yet, he works with our beloved John Romano, who's his father. He works with his brother, Eric Romano, down in West Palm Beach. And he primarily works in the personal injury and the wrongful death arena. That includes interstate, intrastate, trucking, and bus litigation, as well as commercial motor vehicle crashes, motor vehicle crash claims, pedestrian injury claims, as well as vehicle and truck burn explosion injury litigation, as well as motor vehicle liability litigation as well. And then two quick facts real quick. He used to play football for the Iowa football team. And that's where he played for the legendary college football coach Hayden Fry. And then also he used to be in the Marine Corps along with Tom Vesper. So we got two Marine Corps gentlemen here and incredible trial lawyers. So I hope that you guys have a great time this webinar. Please ask your questions. We will get to them when we have our breaks. And otherwise, if you need anything, just make a comment and we will help you out. So let's have a good time.
All right. Well, hey, everyone. Thanks so much. First of all, Ginger, appreciate everything you do for us and for Connectionology. Appreciate our sponsors. Thank you all for your continued support, friendship, and assistance to a lot of us on the Zoom today with our cases. I am very, very happy, privileged, and honored to be able to introduce Tom Vesper, my dear friend and colleague. Longtime stalwart, New Jersey trial lawyer extraordinaire. But what I'm going to do first is salute him because he outranks me, always has, and always will. That is true.
No, it's not. No,
well,
you were a captain. I was only a CW04.
Well, that
I mean, a warrant officer does not, and maybe in the eyes of the enlisted, but I have to salute you, Captain Romano.
Well, I was a Marine Corps lawyer, so we're always outranked by chief warrant officers like Tom Vesper. But no, Tom spent 23 years in the Marine Corps Reserve, retired as a chief warrant officer 4. Tom has vast experience in the Marine Corps, worked as trial and defense counsel, handling courts martialed when he was in the Marine Corps, among many other billets that he held. But in Tom's private practice, Tom practices in New Jersey. As I mentioned, Tom is a stalwart member of not only the New Jersey, New York Trial Lawyers Association, he's a past president of the New Jersey Trial Lawyers. Any of you who've ever been to the Boardwalk seminar where they get 2,000 to 2,500 attendees each year up in
Atlantic City.
Yeah, Atlantic City. Just a tremendous program. Tom's been heading the charge with that program for many years, and we've been fortunate enough to join Tom up there on the panel several times. But if any of you missed the first series of this, you're in for a treat today, because Tom Vesper, not only is he an esteemed author, has tried hundreds of wrongful death, injury cases, criminal cases to verdict. But Tom has lectured extensively to trial lawyers like ourselves all over the country for his entire career, and loves like my father, John, just loves educating the trial bar, especially younger attorneys, mentoring new trial attorneys. And we're going to learn a lot today from Tom and how he approaches wrongful death cases. But as I mentioned, Tom's been practicing in New Jersey, has just a great firm, great track record of results. Tom's an international trial lawyers member, again, longtime member of ATLA, now AAJ, has authored too many books, chapters and books to count. But we're very happy to have you with us, Tom. I'm going to try to handle questions as they come up in the chat, and we'll keep this a free flow, but we look forward to hearing from you, and thank you so much for being with us today.
It's my honor, Captain. Thank you. By your leave, I will tell you what you missed. Part one, and I think you can still get this from Ginger and Connectionology. Part one was about on-call, on-site security, the value thereof, off-site advice, counsel, companionship, survivorship, pain and suffering. It's about all the damages, or not all, but a lot of the damages that are overlooked that will make your wrongful death case for your clients, the survivors of the wrongful death, will make their recovery a full and fair recovery. So we did an actual, we're going to do one day, I guess, an actual presentation. My Uncle Anthony and My Unabridged Analogies, which is a book I put together. That's not my cousin Dominic. That's really the great singer whose name I forget. We did Cooking Cousins. All right. Here's part one that you missed, was to wake up to a new way of approaching conscious pain and suffering, pre-impact fear, the fear of impending doom, which is often overlooked. Unconscious lost enjoyments. That is, when somebody is in a coma, you can still recover for the time that they're in a coma. That's called lost enjoyments of life, or also referred to by some experts as hedonic damages. 24 on-site and on-call services. If you know about these, or you get the part one lecture, you'll find out how you can use these different elements of damage to really double or triple the value of your case. So telling you that, and the three big hurdles you have to overcome. I don't want to waste time getting into that, but definitely the three big advantages of handling a wrongful death case is the jury, the judge, the arbitrators, the mediators, the meditators, who's ever going to hear your case knows up front that a wrongful death case is per se very serious. We're talking about death. Even the right-wing elements of our society get it. What you should remember about the right-wingers, the conservatives in the jury pool, and even some of the judges that went to conservative school, they will give you the monetary loss if you get it calculated. They will give it to you because it's money, and they like money, and most of us do, but the conservatives will give you dollar for dollar whatever your economist says is reasonable, and you have to make it reasonable, and I'll get to that in just a moment with opening statements. The pain and suffering, you may not get a big verdict, but the economic loss, you will get a big verdict. The death rattle, that is the way that your client died. If your client died in pain in a gruesome case where Todd knows my good friend Jerry Baker from North Jersey, he recovered for less than 5 seconds of pain and suffering for a worker a railroad worker run over by a train and cut up by the wheels of a train. Guess how much, Todd, for 5 seconds?
I'll say 7.5 million.
52 million.
Wow.
If you die, or if your client dies a horrible death, you're getting a big verdict. All right. Now, best strategies, understatement, use a designated, a haggler, use somebody else to do the settlement conferences. I don't like to get distracted. Once the trial starts, my partner Rudy steps in and he does all the negotiating. Also, remember what anchors are. Anchors are what the jury knows you're going to reference, and you start with your opening. And I'll talk about anchors in my remarks on openings and anchors, because that's where you want to establish your anchors. These are books to read, $1 a day, in order to evaluate the time that your clients are sleeping together. The people think that's a joke. Professor Frank Teneri, who's there, who wrote a book on economic damages, you got to get that book and read it. And well, my book on my uncle Anthony's analogies and quotes from famous authors and writers and speakers, etc. It does have quotes on damages. Now, here's what we're going to talk about today. I just told you what you missed, and you should call contact Ginger and try to get that program that you missed, which was Wrongful Death Damages Part 1. Here's what we're going to talk about today. The agenda. Let's start with the significant differences and the advantages with 3 types of presentations. What are the 3 types of presentations? Well, why am I doing that? Okay. Let's start with a trial. This scares some lawyers. It also scares our clients to have to go to trial, presenting your case in front of strangers, and you have to convince at least 5 in New Jersey, but in federal court, you have to convince all, a unanimous verdict from the 6 or 12, however many in your jurisdiction. You have to convince the majority or the unanimous jury of the right to recover and the amount that you're going to recover. That can be scary. However, this is what I've learned over many years. It's also scary for the other side. They don't know what's coming in terms of, well, what's the jury going to do? They think they know. Most defense firms that I know do not conduct focus groups. Their focus groups consist of sitting around a table with a bunch of the partners and bullshitting about the case. That's not a focus group. I mean, I used to do that, and that's not a focus group. You call 6 to 12. Usually we have like maybe 10 to 12 random people from your community. And you want to get a good mix of young, middle-aged, elderly, Republicans, Democrats. Get a good mix. And especially, you want to get a mix that is going to match the kinds of jurors that are going to be called to your courthouse. And you present your case. And you know what you'll find out? You're not going to find out the value of the case. Don't think that, oh, well, they gave me, $42 million. I'm going to get 40. No. What you're going to find out is not the value of your case. You're going to find out what the facts or issues or the guts of the case is that's going to drive the numbers up. You're going to find that out. But don't depend on, well, we got this verdict or that verdict. Yeah, that doesn't mean anything. A focus group or a mock jury is going to tell you what facts you need to hammer on or what facts you have to be careful about, which are facts that are going to hurt you or help you. Now, again, a trial can be scary, but it's scary to the defense and to the insurance company for the defendant or the self-insured. often using that element of uncertainty and fear can make for a good recovery, a good settlement. Arbitration. I don't like arbitration. I like arbitration if you get to pick the arbitrators, but the arbitrations that we have in, just to give you an example, and not to mention names, but Ocean County, which is just north of Atlantic County, they have arbitrators that are, they are not experienced trial lawyers. And I mean, this is a true story, Todd. You may not believe this, but this really happened. Jerry Baker and I are giving a seminar, and Jerry always invites, lots of judges, and the judges, and even he had Justice Levesque, I think, was on the panel from the New Jersey Supreme Court. So he had like a Supreme Court justice, a couple appellate division judges, some assignment judges. So they're up there, they're talking about arbitrations, Todd. And this guy, and it's like there's 200-300 people in the room, and this one guy gets up and he goes, "Oh, excuse me, but I'm from Ocean County, and we're having some problems with our arbitration awards." So Jerry goes, "What's the problem?" He goes, "Well, we're just not getting realistic numbers from the arbitrators." So of course Jerry and Jerry says, "Well, I think what you have to do then is kind of vet the arbitrators. You need to get better arbitrators." And he said, and again, he says this, Todd, in front of an entire room packed with lawyers. And then I mean, you're standing in front of these judges that are on the panel, and he says, "Well, Jerry, we're having some tough times economically in Ocean County because of the recession, and so we let some lawyers serve as arbitrators so they can get the $200." I I wanted to scream, Todd. I mean, I just want to get. Are you nuts? You got a welfare program going on, and I got a case that's been pending for 3 years. You got this frick. I mean, can you believe it? But that happens. That happens. There are, even in, not to mention names, but in federal court in Camden, they've got arbitrators on the personal injury arbitration list to arbitrate, and they do real estate. I mean, it's a personal injury arbitration. You're putting matrimonial and real estate lawyers on for what? Okay, that I won't rant any. I may rant later, but I don't like arbitrations where you get this willy-nilly potluck arbitration arbitrators. That is not what I want to spend my morning or afternoon doing. And then you have to prepare an arbitration brief for these numbskulls. If you can pick the arbitrators, especially, and I'll talk about this later, if you could have a blue ribbon panel where you pick one, the defense picks one, and then the two of your arbitrators pick either a judge or a neutral, that's a good panel. That's a good panel. But the arbitration panels that we have now in South Jersey, in words of one syllable, they suck. They're not fit for public consumption. Anyway, let's go to mediation. Now, here's the good thing about mediation. Unlike picking a jury where you might have like one or two jurors that you think are on your side, with a mediation, you know the judge. I mean, the judge knows you. You're not going to pick somebody you don't know. You're going to pick a judge that you know and that both you and your adversary trust. So right away, you're ahead of the game because there's somebody that's going to hear your case that, number one, you know is not going to make a mistake about the law. Number two, they do know the value of cases, because otherwise you wouldn't have picked them as a mediator or meditator. That's just really, really good. The presentation for an arbitration or a mediation, in my opinion, is the same. You prepare a brief. Now, I'm going to talk about briefs when we get to the CDR, CPR, the ADR, the alternative dispute resolutions. I'll talk about briefs when I get there. But you see, there are differences and advantages to all three of these forums. And many, 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 many lawyers today who call themselves trial lawyers have only arbitrated and mediated. They haven't tried any jury trials, which is a shame. And more of our members, Todd, I'm sure you see this in Florida, more and more of our members who refer to themselves as trial lawyers are not trying cases in court in front of juries. They're arbitrating and mediating. But that's for another time, another discussion. Let's talk about jury trials. What I see now is that many, 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 many lawyers are being forced to try cases, number one, because they're shitty cases. They're bad liability, and the defense knows that the lawyer that they're pushing into trial has little or no experience. So they're getting pushed into trial. If that happens, especially in a wrongful death case, any of you out there that have not tried a wrongful death case to a conclusion, to a jury, the defense knows that. They have a track record on all of us. They know how many cases you've tried. Well, number one, and I've seen this list in New Jersey because my senior partner was on a panel, actually on a committee to study med mal cases, and he went and I went and I saw what the insurance companies, all of them had, not just the med mal carriers, they had the list of who the lawyers were that filed suit against their insureds, who the lawyers were that after they filed suit settled without a trial, who the lawyers were that after filing suit went to trial, who the lawyers were who went to trial and actually got verdicts, who the lawyers were that got big verdicts. So if you have a wrongful death case that's worth $1 million and you've never tried a case to a conclusion that ever got anything close to $1 million, you're not going to get $1 million from the insurance company. I mean, unless you're very lucky. So if you're forced to try a case and you know who you are, so hey, I've never tried a case and gotten even a verdict before. What you should do is call a lawyer who has tried a case to a verdict, a wrongful death case preferably, and gotten a big verdict. And you co-counsel with that lawyer, and two things are going to happen. Number one, you're going to live longer because your stress level is going to go down, and you're probably increasing the odds that you and your client are going to get a really, really good and satisfying verdict. So if you're forced to try a wrongful death case and you've never gotten a big verdict and you expect a big verdict, I would recommend you co-counsel. Now, let me talk about voir dire. Whether you have court voir dire, which is what's done in federal court, or whether you're allowed to have attorney-conducted voir dire, doesn't matter. In my opinion, what you have to do in voir dire is alert the jury to the economic damages. In New Jersey, we're not allowed to tell a jury what verdict they should render for not for pain, suffering, um, pre-impact fear, uh, uh, conscious pain and suffering. We can't tell a jury how much we want for those non-economic uh, elements of damage. But economic damages, absolutely. And see, there's two schools of thought on this. My good friend Jerry Baker would say, don't tell the jury any numbers until summation. Wait till they hear all the evidence. If I have a big number, I want the jury to know that up front, because I want them to either throw up or say, hey, if you prove that there's 42 million or whatever, or 20 some $1 million in damages, I'll award it. I don't want them to say, oh no, I could never, no. I mean, I could never give an award of more than $1 million. And there are a lot of people out there that'll say that, honestly, if they're asked, which again, most judges won't ask that. But if you tell them in voir dire and in your opening, what I would suggest is that you tell them what is the amount of damages, economic, if that's what you're allowed to do in your vicinage. You tell them what you're looking for, and you ask them if the evidence proves that my client has lost this amount of $18 million in lost income, and in the advice and counsel that they lost from their father, then do you have any, if the evidence shows that, any problems? Because if you do, say so right now. I want to know that up front. In your opening statement, again, I went back. I'm still on, what am I on? I'm not on film. No, what am I doing? I apologize to you all for my lack of computer skills. So there's two schools of thought. Actually, there's three. The approach for opening statements is, number one, which is my theory, you tell them the amount of money. The second theory is you don't tell them the amount of money. You wait until that comes out from your experts. And number three, you don't give them any experts. You give them the formula, and then you suggest how they should use the formula to calculate the damages. Now, Jerry Baker, Mike Maggiano, who you know, Todd, and several other lawyers that I respect very, very much, they have done this and gotten great verdicts. They don't have their expert. They have an economist come to court. The economist explains, which is a lot better for an economist to do it, especially if the jury's allowed to ask questions. But it's much better if the economist explains to the jury the rule, which the judge is going to read to them, on how to calculate economic loss, because the economist is going to really do a good job of explaining, as opposed to, I mean, the rule, again, the jury instructions they're written by androids. I mean, they're written by, I don't know who writes them, but they're just not understandable. And then the judge, a lot of them, a lot of judges will read it very quickly. You have your economist explain. This is the Jerry Baker approach. You don't give the jury a bottom line number. You give them the formula, and you give them some examples of how they could use the here's the value of a nurse on the open market. Here's the value of a companion. So you give them the values that they can plug in and multiply, and you leave it to their good judgment. Not that I don't trust their good judgment, but my preference is, if you have the opportunity to tell the jury an economic number, I give them two numbers. I never give them one. In my cases, I never say to the jury, our economic expert is going to tell you that the damages in this case are $18 million. No. I give them a range of high and low. Our economic forensic expert economist is going to come here and explain to you why if you use the lowest hourly rate for companion, the most conservative approach to the economic loss, the losses will be $10 million. Net, net, $10 million. If, however, you use and I won't say an inflated number, I would say if you use an acceptable but higher number for the value of the services that we're going to explain to you, then the economic loss in this case will be 23 million. So you have a range, and we had that case. I had that case in federal court. And again, without mentioning names, but Judge Rodriguez would not tell the jury what the range was, but I was going to tell him in my opening, but the case settled. So in my opening, I was going to tell him the range of economic loss in this case is 12 million to, I think it was to 20 some million, 21 something. And so you give him a range. Now, I can almost guarantee that as long as you win liability, the jury's going to come in between that range because the defense is going to give them what we call in Italian lugats. They're going to give them nothing. They're not going to give them a range. They're just going to say, well, that's too high. And even the low that's much too high. But they won't give them a number. So the jury's going to have your range within which to decide. And again, unless they're real conservative, you're usually going to come in within that range. I'll tell you this right now, and I'm not bragging. I'm telling you the God's honest truth. There has never been a jury verdict where I have presented Professor Teneri or his partner, Kristen Kusma, and they have given the jury an economic loss. Now, I've lost on liability, but if I win on liability, there has never, ever been a verdict that's been lower than their number. We've even had, in one case, I told them, you were really cheap on this one because the jury gave us like $500,000 more than what their economic bottom line number was. So, bear that in mind. But you have several approaches to the way that you should present your damages in your openings. And you got to do it. You got to feel comfortable with the way that you give your opening to the jury. Now, the next thing on jury trials, this is important. And it has to do with the concept of recency and primacy. The first thing that you say in any conversation is usually going to be remembered. So the first thing you're going to remember about today's seminar is that Todd and I are both United States Marine Corps members. And then there's recency. The last thing that a jury is going to remember is usually the last thing they hear. So, who's your first witness going to be? In my opinion, if it's a wrongful death case and there's any question of liability, you put the defendant on the stand. In the case that I tried last year, and we got a very nice verdict in July of last year, which, by the way, was just finalized last week after all the bullshit motions that were filed. But anyway, so we got a very nice verdict. The first witness we put on the stand, the nurse that overdosed our client on Pitocin and caused brain damage to the baby. Very first witness. Boom. Did you do this? Yeah. And you did, and you went from a prescription of 1 milliunit with a doctor's order to not increase. You do not increase Pitocin according to the doctor's order and the hospital's protocol. You don't increase Pitocin without a doctor's order. You increased it from 1 to 2, then from 2 to 4, then from 4 to 6, and finally, and this is over a period of like less than an hour, and then finally from 6 to 8, And there was no doctor's order. Is that true? Nurse Ratchet? Yeah. I we didn't have any other questions. That was it. I mean, the case is over. If you have a fall down case, you put the guy on the stand that did you're in charge of the boardwalk in Atlantic City, and you put this piece of wood on top of for people to walk on. Did you know that this wood has 2 knot holes in it? That and when I took your deposition, I asked you, are you supposed to put wood with knot holes up? You didn't know. That was like a year ago. Did you find out after our deposition that you don't put wood with knot holes up? You turn the board over. Did you find that out like since we spoke? I mean, case, it's over. It's over. They put a board, and this is a true story because it's a true case. They put a board with 2, not 1, 2 knot holes next to each other facing up. Guess what happened to the knot holes? They came out like a bad donut hole. They came out. So guess what happens to the wood when the knot hole comes out? It starts to come apart. You put the first witness that you should call is the witness that either demolishes all the defenses and convinces the jury that you should get money because this drunk driver is at fault, or this nurse and the others that followed her that increased the Pitocin without any doctor's order, they should all go to hell. I mean, you know what I mean. So you're going to say you're going to produce a witness that's going to make your case. That's the first witness. Now, if there's no liability question, hey, put your damage witness, the best doctor or forensic economist that you got, put them on. Do not, which many lawyers still do not put your client on the stand first. They're waiting. The defense they've been waiting for 3 or 4 years to cross-examine your client. You don't want a client with a target on their front and back to be your first witness. You want some unimpeachable, or in this case, the defendant who, and you know what they're going to say, you know what they're going to admit to, you put them on the stand first. Who's your last witness? I like to call a rebuttal witness. So the defense called, in one case, they called an economist from Philadelphia, and I shouldn't mention his name. He Paul D'Amato, Todd. He's Paul's brother-in-law, so I don't want to embarrass him, but he's a bit of a defense-oriented economist. He didn't do any interview with any members of the family. This is a wrongful death case. He did nothing. He did Lugats. And so I called in rebuttal my forensic expert to talk about, well, what things did he not do that most economists would do? This was Kristen Kuzma. She went through about 8 different procedures that he did not implement in order to come up with his stupid number. He didn't talk to anybody. He didn't know anything about the kids' education, what the kids' problems were. He knew nothing. So she destroyed him. And in many of our cases, like, again, I don't mean to get off the topic of wrongful death, but you have a defense doctor that comes in and says, well, the fractured patella healed perfectly. It is structurally correct and in the same position it was when this lady was born. Really? So I said to, again, not to mention names, Dr. Friedenthal. I said, Dr. Friedenthal, you said that this fracture left no permanent damage whatsoever. That's right. I said, and I took the x-ray and I said, this fracture is in the patella, underneath the patella. Isn't there cartilage? Well, yeah. I said, well, when there's a fracture at that and it was at the South Pole of the patella. I said, "Wait, didn't the cartilage under that fracture, didn't it die?" "Oh no," he said. "Oh no. There is no cartilage under that part of the patella." So I looked over at the judge, and unfortunately, she had not taken any anatomy courses, and she made it look, Todd. You probably get, well, you probably have never gotten this look, but I get the look from my wife, from Mary Alice, when she gives me that look, like, "You dumb shit, you didn't know that." You know that look. So you get that look, right? And she gives me that look. I wanted to scream because I knew she didn't know that this doctor has just bullshitted everybody. So he gets done, and the defense rests because that's their only witness is Dr. Friedenthal, Dr. F. So I said, "Judge, I'm going to have to call a rebuttal witness." "Rebuttal? Rebuttal?" It sounded like that more, the commercial with the light beer commercial, like, playoffs, rebuttal. You want rebuttal? I said, "Judge, there's a case in New Jersey that says if the defense produces an expert that testifies to something that's unscientific, I'm allowed to call rebuttal. You better show me that case." So it was in my trial notebook, which I always keep that case. Showed her the case. She read the case. To her credit, she said, "Oh, I'm going to let you call the treating doctor, but I'm going to strictly limit you, strictly." And I thought, "You're into bondage now? I mean, what are we doing here?" Sure, I'll be bound to only ask to. So put the doctor on the stand. I said, "Doctor, the defense called Dr. Friedenthal, who told this jury that," and I showed him the x-ray. "So under the South Pole, there's no cartilage." He started to laugh. He started to laugh, and he looked over at the judge and he said, "He actually said that?" Case over. Big verdict. Because jury knew smoke being blown up thing. So I didn't say anything wrong yet, did I, Ginger?
No, I am enjoying this so much. You have no idea. I did not, I did not
I
even want to.
listen. I enjoyed it a hell of a lot more than you did. When the doctor started to laugh on the stand, I knew this is going to be fun. This is going to be fun. The
Yeah.
doctor, and see, here's the sick thing. The defense lawyer had the case won. If Dr. Friedenthal hadn't gone above and beyond with the bullshit about no cartilage, he would have won that case. He would have won because in a verbal threshold case, if the jury doesn't believe there's a permanent injury, you lose. But once the jury knew they had been lied to, and the judge too knew that, yeah, smoke and,
Mhm.
going up this
And
thing.
they're smart. They can detect these things,
Oh yeah. Oh yeah. You don't need a lie detector. I'm seeing
No.
a lot of folks here on the screen. There's Aaron and Patrick. Is
Yes.
this a an unofficial bar meeting? What is this?
No. But we have brought in friends, Tom, so we're going to take a quick break. Um,
Oh, I'm sorry. Of course they are. I knew it was Aaron Gaspard and Patrick Stonick. Am I saying it correctly? Stonich?
mhm.
Stonich.
And is it okay, Tom? I'm going to close out of your slides just for a moment, okay?
Absolutely.
Um, and then I wanted to let's go ahead and introduce Aaron first with HMR. You guys have heard us again rave about this company. HMR has been with us as long as, like, gosh, On Point and all of our other partners for years now. And we are so blessed to work with them. But Aaron's coming in from Louisiana today to tell you guys some of the great things that they do over at HMR and how he can help you and your clients. And Aaron was actually just with us in beautiful Sun Valley, Idaho, a couple months ago for our TBI seminar. But here's the best part. Aaron is coming back. He's going to be with us in Texas because November 6th to the 8th, we're going to be going to an almost sold out conference. If you're thinking about coming to this depositions or trial seminar, you should. Tom, I know you'd be there if you can, but you're probably going to be in trial, if I imagine correctly. But this is an incredible program with Satch Oliver, Dino Colombo, Joe Freed, Christian Morris. The list goes on. It's going to be a great time, and Aaron will be there the entire time, won't you?
Absolutely. And Tom, I'm from Louisiana. When you said bar, I thought we were gonna go have a beer, but I realized we're here with a bunch of lawyers and we're talking about some bar association. But anyway,
Yeah.
now my mind's off of that. No, I am.
Dixie beer.
Let's
Dixie beer.
go. Let's go. I love it. No, thanks for having me. Yeah, I mean, Idaho was beautiful. If you missed it, don't miss it again. I mean, great course. TBIs are one of those underserved things in our legal community, and they just put on a great event, and educating a lot of attorneys, and I had so much fun. I'm definitely looking forward to Fort Worth. I think I'm leading the charge with the horseback riding.
You
So,
sure are.
get your cowboy hat and your boots out. I'll be ready. So, no, thanks for having me. I'm Aaron, HMR, servicing. We're a medical funding group. We have been around for, gosh, going on around 15 years now. And we operate in 40 states. We have case managers that are first class, underwriters that are first class. Kind of what we do from the medical funding aspect is help link you guys up with providers in your area, or get with providers in your area where one of your clients is catastrophically injured. We help set them up with treatment. We help set them up, getting medical records after the treatment. Everything from A to Z, a concierge service, anything I always say from an MRI to a TBI and everything in between. We can help. We have resources around the country. So if you have, clients that are out of state, you're looking for a provider, we can help find you one. And it all runs 0% interest to your client, which is great. So, we know sometimes when they're starting, just even to get an ESI, there's kind of a long runway in between if they have to have surgery. So we don't put any interest on your clients for that. Another component of our company is litigation funding. We know trials are expensive. You're going against multi-billion-dollar, trillion-dollar industries, and you're trying to fight the fight. You're getting experts, you're getting life care plans, you're getting biomechanics, accident reconstructions, whatever you need to build your case and go to trial and go to battle for your client. We can help pay those invoices at a really fair market interest rate. And so we also know that the third component of our company is client advances. We know sometimes they're out of work, they're hurt, they need to pay bills. I had a lady the other day that was about to lose her house, and we were able to advance her money to keep her home that she had had for 35 years. So, a lot of times we're there to help you guys fight these big entities, these big insurance companies that have an endless amount of money. And we know that you guys, need help with it sometimes. Your clients need help, and that's what we're there for. And so I'm going to put my information in the chat room. Look, if you want to have a conversation about anything, if there's anything I can help you with, even if it's outside of what I do, I'm a resource, and I love to connect with people and connect people and help others. So, and that's what it's all about. If we put the client first, we all win, right? I mean, so that's what HMR stands behind. Not just money, because money can be boring, but you need it. I love to connect people with experts that are top notch around the country. So if you need anything, give me a shout. Ginger, thank you so much. Tom, Todd, keep fighting the fight, man. We love you guys.
And it's great that you said that too, Aaron, because John Romano, and I know Tom and Todd have heard this before, but John always says your agenda is the client, the client, the client. Like you got to keep going back right to that and what they need help with and what they need. So,
Good.
all right. Well, you put your information in the chat box, so I hope everybody is going there now, putting your information and putting it into their phone, because I know that you can be reached at any time, especially if anyone has any questions, and you are a wealth of knowledge. If you're looking for anybody in certain states, they can just call Aaron, and I know you'll help them out. So thank you. All right, and I see Patrick is coming from On Point as well. He's going to be with us in Fort Worth, Texas for our depot program. And he's been a nurse for, gosh, over 21 years now. He's going to talk to you about some of the great things they do at On Point, but he has worked in the hospice, home health. I'll let you go dive in a little bit more about that, but you've all these nursing home facilities. I mean, but you've also spoken on a lot of our webinars when it comes to nursing home abuse. And I know that you testify around the country, and you do a great job at it too. But we love working with you and all of the team members over there at On Point.
Well, thank you very much, Ginger. Todd, nice to see you. Tom, it's nice to have another Northeast representation up here. I'm a Villanova kid, so um, we're right in the same neighborhood. Like Ginger said, my name's Patrick. I'm one of the directors over at On Point, and I've been a nurse for 22 years. I studied at Thomas Jefferson University in Philadelphia, and I was a nurse in the hospital in the cardiac ICU for several years, and then went into the crazy world of long-term care, home health, hospice, and skilled nursing facilities. So I'm one of the nursing experts that see a lot of cases for nursing home abuse, neglect, wounds, of course. But other things that we do over at On Point, we have a full team of nurses that run the show. So myself, Ingrid, who's been a nurse over 42 years, Dawn has been a nurse over 30 years. So when you call On Point, you're speaking with nurses that have been still clinically active, that have been in the business for a very long time. I'm the junior at 22 years. So you really get to speak with someone who knows the medicine and understands what you guys are going through with the medical records and the charts, and kind of trying to understand all of the inside looks of the record. So we can start with merit screens. We can start with record retrieval and organization. We have a new program in place that will turn around records and a chronology, medical summaries, within 48 hours. So you'll get a really good picture, have organized records. Nurses will put in their comments, so you can see kind of some red flags as you start looking into the case from the very beginning. Some of our specialized reports, we do pain and suffering reports, which is a non-economic damage report. We do have 3 certified life care planners on staff that can do the life care plans. And then, of course, we have a wonderful database of nursing experts like myself, and also medical experts, engineers, accountings, and other experts out there. We, of course, work with HMR. We've sent over experts there and vice versa. We worked with Strategic, Fox AE. So we all are a wonderful team that are here to help you guys out. We like to consider ourselves an extension of your team. We're a phone call, a text, an email away. If there's a medical question or a nursing question or something that comes up, it's very easy just to give us a call, and we can help you guys out before you go down some Google medical rabbit hole. So we're here to help. Connectionology is always amazing. Ginger, you're fantastic as always. And every time I learn something new. Tom, I've learned a lot. Wonderful stories as always. So looking forward to seeing everyone in Fort Worth and then on the next Connectionologies.
Absolutely. I tell you, I did not want to, I'm just having everybody speak now just because I don't want to take any more breaks after this because, again, Tom's stories are so good.
It's a
Um,
Villanova tradition.
Very true.
But Patrick, thank you for all that you guys do. And again, I hope everybody also saves your information. This is kind of like the one-stop shop where you can find all these great people that we work with, and you guys can work with them too. So we're very blessed in that respect. So thank you, Patrick.
You're very welcome. See you soon.
Yep. And now Sam is coming in, and Sam is definitely one of my favorite people because he's doing things that is just so unreal. And I also happen to be very, I don't know, I was just telling Tom and Todd earlier, like the whole investigation thing is just mind blowing, the things that they can do. But Sam's company, Strategic, actually can go out there and help find ex-employees of all these different companies. And he helps give you this information in this incredibly detailed EEL report. I'm gonna let him share a little bit more about it, but like I said, mind blowing.
Thanks, Ginger. And good to see you, Tom and Todd. And Tom, we get to work with Tom not that long ago on a case. And unfortunately, the guy that we were trying to find was no longer here. But, what we do really more often, our company, is the guys that track down the former employees of your defendant companies. And we help convert those folks into insider witnesses. So really what that means on a case-to-case basis is we're working on nursing home cases, elder abuse cases, trucking cases, product cases, finding former engineers and nurses and drivers who could talk about conditions within the company. What we do is really, you come to me and you say, hey, Sam, we are suing or looking to sue this company. We want to find people who held X, Y, and Z job titles from the years 2015 to 2018. And those people can be anywhere in the states now, or they need to be geographically in this state or that state. And what we do is we find people that meet those criteria. And the idea is you get a big list of people who meet that criteria, and you funnel that list down into through interviewing the prime time folks who have the specific knowledge and want to work with you. Some of our clients use us to just produce the list of former employees with their names, their job titles, their tenures, their active phone numbers. Others choose to then rehire us to interview those people and gather the story. And what we do at that point is really we interview them, we learn from them, and then we connect you with the good leads so that you guys are busy. You got busy schedules. What we're doing is we're taking our trained interviewers to actually funnel through those calls and get the good leads. So if you've got a case that you think is a high damages case, a wrongful death, a nursing home, a TBI, where people that can come in, former employees, have information that you're not going to find in traditional discovery, give me a call and we can talk about how maybe we can come in and bring some more value to your case. So I'll put my stuff in the chat and then I look forward to speaking with you.
And it's also, Sam, how amazing it is that people are willing to talk. You just got to find them and they want to help, they really do. When they hear
They
about what's
really,
happening. Mhm.
they really do. And actually, a question that sometimes people ask me is, well, what are they getting out of this? Because I think people are like, are we going to pay them too? Or what, how does that work? People really genuinely, people leave their jobs because they didn't like it for some reason or another, or they got another opportunity somewhere else. And so often we get on the phone with these people and they're like, I just wanted a place to tell my story. I didn't even think that there would ever be an opportunity for this. And so we really just give people an opportunity to tell their story that they didn't think they'd ever get the chance to. So it's cool. I really enjoy what we do. It's really fun. And I hope we get to work with you guys.
Yep. And if you're coming to Fort Worth, have dinner with Sam and he'll tell you some good stories too, right, Tom?
Right.
All right. And then last but not least, I'm very excited, and we're going to get back to Tom's presentation. I wanted to bring in Ryan, another great company that he works for, Fox AE, that can handle all of your animations, graphics, demonstratives. They can do anything. And then also, Ryan, Cody was just telling me some very cool information about your background the other day that I think you should also share with everybody.
Thanks for having me, Ginger. I always love coming on here. Um, I am a neuroscience major background. My plan was originally med school, kind of changed up when I got towards the end of school, but love everything neuro. That's why all of our TBI cases, all of our spine injuries are right up my alley. So we love animating, bringing your cases to life, those complex cases that really need to be simplified. We love communicating that story so that the jury can understand better. Memory retention is way higher with things that they can see, and they pay attention. So yeah, animations and visuals for any personal injury case. We can do accident reconstruction. We can do medical malpractice, show surgery's gone wrong, show procedures needed, take your imaging, put it next to our animation to clarify what's going on there. Really anything, any direction you're looking to go with your case and your visuals, we can help out with. I've got a quick example here just to give you an idea. This one is a product malfunction in a car with the seat. So I've sped it up a little bit here. But in this case, the seat malfunctioned. We go into exactly where the seat malfunction was. It's in the backrest. And you can see how crazy and how significant this injury was because of the malfunction. And then we'll go in on most of these and show the actual mechanism of injury. She ended up being a quadriplegic after this. Yeah, very significant injuries there. We can focus in on any injury. Like this one, we bring in the imaging, match it up. But yeah, just one example of the stuff that we can show, and very impactful for the jury and for everyone that's there. So yeah, we'd love to talk about your cases. We'll brainstorm with you. We've always got ideas because we've done so many of point of views, different ways to show what's going on. I'll put my information in the chat. We also have a stock website, Fox Prime. If you do need something quick, you can search it in there. But yeah, reach out. Let's talk about your cases.
Perfect. Thank you so much, Ryan. And please put your information in chat box along with that website, Fox Prime, because I think people are definitely going to want to check that out. And then we will see you back here in the next webinar.
Thanks,
All
Ron.
right. All right, Tom and Todd, back to you guys. I am not going to interrupt you anymore for this duration of the webinar, and I'm looking forward to hearing more. I'm learning a lot today.
Go Birds,
Feel
Tom.
Feel free to jump in. And
Tom,
thank you.
Tom's got the Super Bowl winning Eagles cap on now, huh?
Yeah, there you go.
I won't ask you about the Phillies score last night then.
Oh, God.
Uh,
Please.
now,
I wanted to say something about my Villanova compatriot there. If you have a complicated course of treatment for, and I guess this could apply also for wrongful death cases. If you have a lot of medical records, I want you to know that I've done this twice. When there are many, many medical records, you should call. And what was the nurse's name again, Ginger? Was
Patrick.
Patrick. Patrick or anybody, obviously, Patrick could do it, or anybody that works with Patrick can take the medical records and read them to the jury. It's a lot better to have, especially if there's a long course of treatment. There's a lot of medications. Then a nurse can do that, and I know the judges allow it because number one, it saves time. Number two, it helps the jury because you don't have all these records coming in, and who the hell's going to read them? The jury's not going to read them. And if they could read them, a lot of the handwriting can't be read. So you have a nurse testify in your cases to the medication that was given, the course of the hospitalization, and where in the hospitalization before the plaintiff died, there's evidence that the plaintiff suffered. The nurse can explain that to the jury, and then after the nurse explains what's in the medical records to the jury, then you have the doctor testify. But the doctor doesn't have to go through all that medical jargon because the nurse has explained it. So I would Patrick gave me that idea as he was talking. Use nurses to help you to make it makes the trial go a hell of a lot quicker. It makes the injuries that your client suffered a lot more understandable when the nurse explains, well, the medicine here was increased 3 times. They were in a lot of pain, and I can tell that because, okay, nurses do that such a great job. Now, I also want to give a plug to Ryan. Anytime you have, especially in a wrongful death case, you have a chance to illustrate how your client died, the value, I think that doubles the value of your case. And it sends a message too. If you're going, let's say, we're talking now about, what are we talking now about? Well, let me finish. I was talking about jury trials and the last witness. Let me talk about summation. In summation, you don't have to overdo anything. The jury understands there was a death. There's a loss as a result of the death. You don't have to belabor anything. A lot of times what I do in summation is I just pick apart what the defense is trying to do, which is usually to minimize the injury or the death. And you could have a lot of fun in summation. The trial, for the most part, I mean, a lot of people believe, I know, Todd, your dad believes that if a case hasn't gone in properly, summation is not going to save it. It's not, I mean, it doesn't matter. If a case, if the scales of justice are teetering, yeah, then a good summation can win the case. But if you haven't convinced the jury by the end of the trial that your client the death was caused by the defendant, and the damages are legitimate, summation's not going to help. I don't think. So in summation, you want to be very careful that you don't do anything to annoy the jury. You don't want to belabor things. You just want to hit the highlights and again emphasize what you want for damages. Emphasize there's a time unit rule that I love to use. If my client suffered for 30 days and 30 nights, which she did before she died, imagine 30 days and 30 nights. And then during that 30 days and 30 nights, my client lost something, not just the right to live pain-free and a normal life, being in a hospital. They lost the opportunity to say goodbye. And one judge said to me, Mr. Vesper, your client only lived for 1 minute, and you really want me to tell the jury about the loss of enjoyments of life for 1 minute? I said, of course. And I'll tell you why, Judge, just in case there's some lingering doubt in your overly conservative mind. During 9/11, when people were trapped in one of those two buildings, you know what they did? They knew they only had seconds to live. You know what they did? They called the people they loved to say goodbye. And my client didn't have the chance to do that. So I want you to tell the jury what I'm going to tell them in my summation is a legally recovered right, which the Supreme Court of New Jersey says it is. So yeah, please, Judge, don't try to belittle this. And they will say, oh, Judge, it's only a minute. Was a minute? There's a hell of a lot you can say in 1 minute to the person that you love most on this earth. So that's summation. Now, I want to go to the complementary dispute resolution methods. Arbitration, I've already told you, I think is potluck, and I don't like it at all. Unless you can pick the arbitrator or in Atlantic County, there's two arbitrators, a plaintiff and a defense lawyer. Most times, neither of them know shit from Shinola, excuse the expression, but they're dumb. They're dumb, and they have no experience. So I don't like arbitrations, but I've already said that. Not to belabor that point, when you go to mediation, well, let's stay with arbitration. You're going to go to arbitration with one or two lawyers. In New Jersey, you have to, unless, of course, you file a motion, which I do all the time, to get the hell out of arbitration and go to mediation. But if you're going to go in front of an arbitrator, you got to have a brief. You got to have a brief. I've seen lawyers go to arbitration, and I've been an arbitrator in Atlantic County in the courthouse, and they come in and their arbitration material is a stack of records. I'm not going to read them. I mean, they give me a stack of medical records and reports. What the hell? I mean, they didn't even highlight anything for me. Just a stack. I'm not going to read it. And a police report. Okay. I'll read the police report and then I'll listen to the testimony, but I'll tell them I'm not reading that stack of shit. I'm not reading it. If there's something in that pile that you want to draw my attention to, highlight it or tell me about it. But I'm not going to read through all this to determine, just like giving somebody the entire deposition. Are you nuts? Like, and I'm going to read this now for the 30 or 60 minutes that you have allotted for arbitration time. That's the other joke about arbitration. You work on a case for 2 or 3 or 4 years, and then they give you a half an hour to present it. I mean, it's not fair. It's not fair at all. And then both sides, we each have 15 minutes? Whoa. Whoa. And then you're going to hear the testimony of my client, right? All within 30 minutes. Okay. Yeah, that's justice. So at least when you go for a mediation, you got all day. Well, if you're going to take the time for a mediator, or let's go back to arbitration, even if they only give you a half an hour, if you write, and it shouldn't be longer than 10 pages, but if you write a brief, you tell them why you should win, liability. Here's what I do. My briefs start out with a little bio. Here's who the plaintiff is. Here's where they were born. Here's where they went to school. And a lot of lawyers will say, oh, Tom, even my partner, Dara, says to me, why do you do that, Tom? Nobody's interested in where they went to school or whether they played high school football. I said, really? Really? I said, Dara, I want to tell you what just happened. And it happened this year. True story. My client and the witness who was with her when she fell at the casino were both born in Greece on this little island. Nobody ever heard of this little island. I mean, it's not like Crete. They weren't born on Crete or Mimosa, whatever the islands. I don't know all the Greek islands. She's born on this little island. All right. With her aunt, who was with her when she tripped at the casino. We go to arbitration. Todd, can't make this shit up. One of the arbitrators is a lawyer who I've known for many years. She does defense work. Okay, good defense lawyer. And I knew I was going to get a low number from her because that's her religion. You know, that's who she is. She's just low on everything. So, lady and a gentleman who was the plaintiff lawyer. So the defense lawyer says to my client, you were born on the island of Monacobus. Am I yeah. She goes, and so the defense lawyer says, my mother was born on that island in a little village that's like around the corner from where my client was born. Now, we got a very good verdict from that arbitrator, a very good verdict from the two arbitrators together. There was a connection made. I really urge all of you, when you're doing an arbitration or a mediation brief, do just a short half page or full page bio of your client. Here's where they went to school. Here's some of the achievements. Here's what shows that they were hardworking throughout their life. Here's some of the things they enjoyed doing. Here's some of their accomplishments. Okay, do that, and then you do liability. Now, I've actually put, and I call it an arbitration or mediation brief because I put case law into the brief. Either the model jury charge to show I don't have to prove notice when an employee of the casino created this dangerous condition. I put that in there. I don't put that in there because I think the arbitrators are stupid. I don't put that in there because, well, some of the defense lawyers, but I don't do that for the arbitrators or the defense lawyers. I do that for the adjuster because many times the adjuster that's going to read my brief, they don't know the law, and their defense lawyer has never explained it to them the way I wrote it, which is the way the model jury charge gives it. It's not like I make shit up, although I do that too, as Todd will attest. So I'm not making this up. You do the brief bio, liability with case citations or model jury charge, and then you do the damages. Maybe you do the treatment in chronological order, or what I'm doing nowadays, because the treatment sometimes is extensive, I put the treatment as an exhibit in the appendix in chronological order. If they want to see all the treatment, they can go to the appendix. But I summarize. Here's the plaintiff's treating doctor, my examining doctor. Here's the rebuttal to the defense doctor. And let me tell all of you out there, whether you have a wrongful death case or a personal injury case, never, ever, never let the defense supply a report, whether it's an economist on a wrongful death case, or it doesn't matter. Never ever let the defense submit a report that you don't give to your expert for a possible, and it's usually a probable, rebuttal. Many times the rebuttal report you get from your expert is better than the original report, because like in the wrongful death case we had, where Kristen Kusma criticized the Paul D'Amato's brother-in-law from Philly, what he wrote, it was ridiculous. And she said so in, like, in professional terms. She didn't say that's bullshit. She just used a professional scalpel to take him apart. And when she testified in front of the jury, she was our next to last witness, Todd. She was amazing. The last witness we called in the verdict that we got a year ago, they called one of our experts a liar. I called a rebuttal witness. She's the head of neurology, or the head of neurosurgery at UCLA. She came in on Zoom live. This lady been a doctor for, I don't know, 50 years. I said, do you know Dr. Schifrin? Again, not to mention names, it was Dr. Schifrin, who they called a liar. So you know Dr. Schifrin? Absolutely. Do you consider him to be an expert on, birthing defects? She goes, he is known worldwide. I said, well, is he respected in the community? Because you have an opinion. She goes, you're allowed 2 opinions on rebuttal. You're allowed to have your character witness testify to 2 opinions, their own opinion and their opinion of the reputation of the witness that they're testifying for, their reputation in the community. So first I said, what's your opinion of him? She goes, he's the most honest, thorough, knowledgeable doctor I've ever met in 50 years. He taught me. He invented a machine that monitors fetal heart rate. He invented it. So, and then I said, well, what's his opinion do you know what his opinion is in the community of neurosurgeon, of neurology? She goes, everyone uses his fetal monitor. Everyone relies on him. There are doctors that do defense work and they call him for advice. So his reputation, outstanding. I said, well, in this case, he's being accused of being a liar. And she went, not Dr. Schifrin. It's not in his character to even exaggerate. That was the last witness that the jury heard in that entire trial. And the jury awarded, as you know, Todd, a lot of millions of dollars, because they knew, just like the jury knew that Friedenthal was blowing smoke up there, what, they knew they had been lied to. They knew that what the defense was doing was absolute, just wrong. They were being insulted. And a jury that feels insulted, they're going to punish somebody, which they did. So I guess I did some, so now I'm on a complementary dispute resolution and ADR, and that usually involves a retired judge. So what Ryan Green talked about exhibits, if you, in a wrongful death case, you add an exhibit that shows how your client died, how they suffered, well, I mean, it adds to the value of the case. It does something else that's probably just as important. It certainly helps the mediator to understand that, hey, this is a big case, not because your exhibits are big, but because you've taken the time to do that. And it tells the defense, this guy or this lady, this trial lawyer is ready to try this case. They've got their trial exhibits ready. Now I know John does that. John wallpapers the damn wall with he'll come in, Todd, you're laughing, but it's true. He'll come in with a truckload of exhibits and just post them all over the place. You won't be able to find the bathroom because John's got it blocked with his exhibits. And
Yeah. His middle name is demonstrative aid.
yeah, yeah.
Demonstrative exhibit.
I know, and you do the same thing, Todd. When you have a case that it just screams for a visual. It sums up. You don't have to read the brief. If you have a photo of the collision and the damage done to the car, you hold that up. That's done. Okay, and now the injury. You hold up one of Ryan Green or Fox Prime's. You're like, there it is. Okay, boom. That's it. I really don't have anything else to say.
Absolutely. Yeah. Big proponents of demonstrative exhibits, and we've started embedding, photos, graphs, if we already have demonstratives in our complaints even. And it's
Yes.
just,
Yes. Who started me on that was Mark Kozorotsky uses a lot of embedded diagrams and exhibits. I was doing that until the Supreme Court of New Jersey and the court rules said you can't do that anymore because it was driving the file clerks crazy. So now, the hell with them. When I got around it, instead of embedding the exhibits, I just attached them. So yeah, it works. It works. It's not as neat. It's not like reading a USA Today where you got the graph is right there, and you're reading it. It's like a newspaper. But all right. So I want to say one. So here's the other thing I want to say before I run out of time, which I have like another 10 minutes. Yes, no.
Take your time, Tom.
Thank you. All right. So in an arbitration, well, I can't do it in a half an hour arbitration, but I can do it in a mediation. You can call live witnesses. And I have a mediation coming up next week where a tent was set up on the boardwalk by a casino as a gimmick. So this tent is set up, big tent too. And guess what happened? The wind came along and blew it into the next county. And my client, one of the people that got injured, standing under the tent, got hit by the tent pole that was not secured. Now, their position is, oh yeah, we secured it. I have I have 3 witnesses that saw that the metal posts on the 4 corners of this tent had nothing, no sandbag, no. Well, you can't put nails or screws into the boardwalk unless you ask permission from the city, but nothing was anchoring the 4 posts. And I'm going to have them here for the mediator so that he can see these are 3 people have nothing to do with my client. It's not like, and his brother was there, but I'm not calling his brother as a witness for the mediation. I'm calling 3 independent eyewitnesses so that the defense lawyer and the adjuster is going to be here for the mediation. Sometimes the judges order that, Todd, that all parties have to be there for the mediation. So I want the mediator, I want the adjuster to see these 3 people are going to testify at trial. If you have the nerve to try to say that this tent was properly anchored. Another example of a live witness. It was not a wrongful death case, but it was a personal injury case. And you can apply this to a wrongful death case because the defense was raising the argument that the herniation was old and not new. So the mediator said to me, I read the report of Dr. Christini, not to mention names, said, and geez, I'd like to ask Dr. Christini a question. So I'll get him on the phone. I just happen to have Dr. Christini's home phone. I knew he was going to be home. So I call it, John, you there? Yeah, the judge has a question for you. And the mediator got to talk directly with Dr. Christini about Dr. Christini's report. If you have a question that's going to come up at your mediation, and it involves one of your experts, have your expert on call, so that if the judge is going to say, I don't understand how Kristen Kusma got to this bottom line number for the loss of services in this case. Okay, you call Kristen. Okay, you have that flexibility, especially in mediation, live witnesses or on call witnesses. Now, I'm going to finish up with some new. So I call it something blue, something new. What did I call it? Something borrowed, something blue. Okay, there it is. I'm not following my own outline. This is not fair. There it is. All right, new ideas for death cases. Here's the new idea. I lost. Wait a minute. That's not, I don't want that yet. Okay. It's, you can tell how adept I am at doing this. So E&E, what do you know what E&E is, Todd? I can't see you, but I'll ask you the question anyway.
Does not ring a bell. No, I don't.
Okay, well, in our court rules, I've actually helped some judges find this in our court rules. In our court rules, we have a rule for what's called early neutral evaluation, an E&E. Now, what that means is that even before you file a lawsuit, you can ask the defense insurance company, or in this case, Boscov's is self-insured. I've had five over the last 2-3 years. I've had 5 E&Es. And these E&Es are, we pick a judge, retired judge, they get a defense exam, so they have a report. We go, just like it was a mediation, we go to the judge's office, or the judge comes here, and we present the case just like it was at arbitration or mediation, and the judge puts a number on it. And all 5 of those cases, without filing a lawsuit, all 5 were settled. It's called early neutral evaluation. If your court rules don't have it, look in New Jersey for complementary dispute resolution, E&E, and you ought to have your rules changed so that you can have early neutral evaluation as a court rule in your jurisdiction. The other idea that I want to throw out is, even though I can't tell you how much I hate arbitrations, but a blue ribbon binding arbitration is almost as good and almost as fun, not quite, but it's almost as fun as a jury trial. Because what happens in a binding blue ribbon, it's got to be a blue ribbon. It's you pick a plaintiff lawyer. The defense picks a defense lawyer. The 2 of them pick a judge. So now what you got, if you're a plaintiff, you've got 2 votes. You got the plaintiff vote and you got the judge's vote, because the judge was picked by your guy or girl. The blue ribbon panel is going to either render a non-binding or a binding. If you're going to go to the trouble and the expense of having a blue ribbon, it should be binding. And the blue ribbon panel decides liability and damages. In a wrongful death case, it's a big time saver. It's a big cost saver to everybody. And again, if the defense is truly interested in settling the case for a reasonable number, you're not going to get some runaway verdict from a jury. Okay? I mean, we got not a runaway verdict, but we got a very large verdict against the nurses last year for several reasons, and that verdict is going to stand. But the defense in that case, if they had gone with a binding arb, they would have probably gotten a much lower number, and they wouldn't have gotten a hurt. But They didn't. And they went with the jury. And they I don't want to get into that case. Anyway, blue ribbon binding arbs work. Early neutral evaluations work. Actually, any of the forums, jury trial, arbitration with the right arbitrators, and mediation will work if you are thoroughly prepared and you're ready to fully present your case in the best way possible. So I hope I've left you with some good ideas for wrongful death cases and other type cases. And if Todd, you want to add anything to what I have spoken about, please let me hear from you.
All right. Well, thank you, Tom. I mean, this has been just a wonderful 90 minutes, and believe it or not, you went 90 minutes and you didn't drop one name. So
Right. I try not to. I
I know you said you weren't going to identify anybody by name, and I think you avoided doing that. No, one thing I will add, I was going to jump in at the beginning, but some of the things you said at the beginning made me think of this when you were talking about trial risk and both sides being worried about the case, and the other side is worried about a case. But if any of you ever get the opportunity to be personal counsel for somebody, take that opportunity and act as personal counsel. If you have a family member, relative, friend that gets in, say, a motor vehicle accident, and another person is bringing a claim against them and their insurance company, jump in, send a personal counsel letter. I can email you what we send to our clients or our friends, relatives, insurance companies, letting them know that you're going to be personal counsel alongside of the appointed insurance defense counsel, but you then get to be in the defense room. And, we all go to mediation all the time. The defense is pounding their chest. We're not worried about this case. We have no risk. We're going to kick your butt. We're going to pound our chest and posture. Well, that's not what's happening in the defense room. And I've gotten to be in the defense room at mediations. You get all of the lawyers' reports to the insurance company. Tom talked about it. They keep scorecards on the plaintiff lawyers. Are they going to try a case? Have they ever tried a case? But it is so insightful for what we do as plaintiff trial lawyers to get to be in the defense room if you've never acted as a defense counsel. So, don't ever push off the opportunity. If somebody calls you, hey, I got in an accident, what do I do? Oh, call a defense firm. Act as personal counsel, and you get to be in the room. It's so insightful for what we do. But that's all I wanted to say. But Tom, as always, entertaining yet full of great information for what we do and how to approach damages and wrongful death cases. I know let
me leave you with the final tip.
Go ahead.
I almost forgot the phylum terminale. And I think it was your dad that asked me. Yeah, your dad asked me this in Wrongful Death 1, the first part of this 2-part program. He said, Tom, what over the years, what do you think is the best advice you could give to young lawyers that are starting out to be trial lawyers, trying cases in front of juries, not just meditating, mediating, and arbitrating? I said, well, the best advice is what I learned very early. Actually, my father, Rocco, taught me this. If you're going to get into the ring, you don't look for where to lay down. You're going to get into the ring to fight. You're going to go to court. Don't look for a place to lay down. And if you're going to get into the ring, you can't be afraid to lose. So if you're going to try cases, don't be afraid to lose. If you are afraid, that's when you really have to ask for somebody else to help you, not for somebody else to take it over, because then you're not going to learn anything. you ask for somebody else to try the case with you. Don't be afraid to lose. That's my Phelan terminology.
Great advice. Well, thank you again, Tom. We're gonna let me bring, okay, we got Ginger and Ted back in for, is this for the coffee give? Hey, Ted,
It
for the
sure
coffee
is.
giveaway. Okay.
Oh, yes, Todd. And I can't wait to see who the winner is. You guys know that a webinar would never be complete. We cannot finish it without bringing Ted in to share who the winner is of the special HMR coffee giveaway, in which they're going to get 2 bags of this freshly roasted, I think it's Costa Rican still, right, Ted?
That's exactly it. Yeah.
Absolutely. And then they get a very cool coffee mug with HMR on it as well. So I can't wait to see the winner is. Ted, first of all, how are you doing? Do you have anything to announce for us before you announce the winner?
No, we're doing great and just, staying super, super busy. So, I think it's such a pleasure to be able to help plaintiff attorneys across the nation. So we just love what we do, and we love being able to help you guys. And just my favorite part of the day is giving away caffeine. So, um, so I know Aaron was excited for going to the bar for beers, and I'm excited to give away coffee. So, we make a good group over here.
Well, I'll tell you what, Ted, let us know who is the winner of today's special coffee giveaway.
Yeah, so it's Kent Buckingham, and he's out of Santa Fe, New Mexico, is our big winner today. So
Oh my
congratulations.
goodness. Congratulations, Kent. You know what is so cool that you just mentioned that is because Santa Fe, we've done, I think, like 3 seminars out there several years ago. We were doing it every single year. And still to this day, Doug Beam said that is his favorite seminar we have ever done.
Mm.
And I think there's talks about going back to Santa Fe soon. So I can't wait to get the word on that. But thank you so much, Ted. That is awesome that you came in today to announce the winner. Looking forward to the next webinar because there's more chances to win. So don't feel bad if you didn't win today, guys.
Yeah.
But the good thing is everybody won because you got to hear some great tips from Tom and these amazing takeaways. And Tom, I will email everybody your slides after this webinar. If anyone does need the slides for part 1 and you missed it, let me know. I'll send those to you too. But please contact Tom, contact Todd. If you have any questions, reach out to them. They are just a world of knowledge. And again, like I told Tom, I could listen to him if he's talked all the way through Saturday. So you guys love the comments you're putting. I don't think you can see this, Tom, but they are putting the sweetest compliments about you in this chat box. A good friend of ours, a trial lawyer out in Hawaii, his name is Sergio. You spoke out there about 15 years ago in Honolulu,
Yeah.
and he
Yeah.
still remembers that talk. And he
Oh,
says
wow.
you changed his whole entire practice. So you did
Really?
a great job. I guess it's time for you to go back to Honolulu, okay?
I would love to. I think it was the Chief Justice of the Supreme Court was there that day.
Mhm.
And I said something about the Supreme Court, which I hope did not offend him, but that was a really, really good, it was a great program at a great location. Yeah, it's just a beautiful spot. I'll go back anytime, tell him.
Deal. And I think John would go right there with you.
Here
He
you
loves
go.
Hawaii.
There you go.
And then looks like Santino said he really felt that when you were talking about that 1 minute. Great example that hits home. Thank you. And then I'm so excited, Miss Angela Trawick, another great trial lawyer here in Florida. She said that was so informative and entertaining, Tom. And she is coming to Fort Worth with us, and she's going horseback riding with Aaron, Ted.
Right. Okay.
Well, I will be leading up the cowboy and the cowgirl hat decorating thing where you can brand your own cowboy hat.
Yeah, you gotta have a hat. You gotta have a hat.
Because we're going out to the world famous Billy Bob's, which is a huge, I think it's the world's largest honky tonk. We're going to do a barstool chat with Seth Oliver and all of our speakers.
Oh,
And then
wow.
we're going to go watch a bull riding show. So we're going to have a great mixture of getting that one-on-one CLE experience, learning all about depots from some of the greatest trial lawyers in a small setting. Because this program is like 80 trial lawyers or less. We don't want this to be a big one because you're going to break out into groups of about 12 every day after the general session. And then, of course, I get to lead everybody in the fun stuff
There you
afterwards.
go.
So,
Good job. Good job.
Yeah. You should really think about coming out to see us, Tom.
I will think, yes, I will think about it.
But thank you guys so much. And Todd, you were amazing. I know you've been in the middle of doing trial after trial and working on depots and hearings, and the fact that you were here with us today means so much to us. I hope everyone will also reach out to you if they have any questions. But I'm starting to realize there's a good similarity between you two. So not only are you great, or were you great Marine Corps representatives, but great trial lawyers, but there's got to be something with that, being in the Marine Corps, because I mean, John's got it too. You guys, it's good synergy. So
Well, and Tom can probably still fit into his dress blues.
yes.
Barely, but yeah. Yeah, you're right.
All right, guys. Well, we'll see you on the
All
next
right, thanks
webinar.
everyone. Tom, thank you. Good seeing you.
Very well. Thank you, Captain. Till
Go to
that time.
Connectionology.
Thanks, Ginger. Thanks, Ted. All right.
Thank you, guys.
Take care, everyone.
Stay updated at connectionology.com for even more webinars, and be sure to share those with all of your colleagues. We'll see you guys next time. Bye, everybody. Thanks, Todd.